I mean, what does the Supreme Court do? I mean, if they were to take up every single case that misapplied Bruen, it is literally all they would do, all all session long.
Yeah.
We are the Armed Attorneys. Today we're talking to you about whether or not the government gets to tell you you're not allowed to train with your firearm. We're going to talk about what New York State Pistol and Rifle versus Bruen covers. Does it cover training? We're going to talk about the new trend with local governments. And finally, we're going to talk about why apparently the government does not want you to be good at shooting. But before we get started, show your support for the Second Amendment by hitting the like button. And check out the link in our description to the Armed Attorney newsletter. Sign up. We're going to push out some really good content. And if you've been watching the channel this week, you already know why.
So we're looking at a new circuit court case. I mean, this isn't just a lowly district court analyzing the Second Amendment as it relates to outdoor shooting ranges. Now, we've spoke about kind of zoning ordinances in the past. We'll link that in the description below, and how there was a prohibition on a city saying, hey, shooting range, you can't sell guns. We zoned you that way. Well, this takes it even a step further, and it's cause for concern because this is out of the Sixth Circuit Court of Appeals. And so we got to talk about this case a little bit because it is very illustrative of how local governments are getting around the Second Amendment. But ultimately, we're looking at the standard that was handed down by the Supreme Court and New York State Rifle and Pistol Association v. Bruen, and how should courts judge Second Amendment infringements? We look at the conduct. Is that covered by the Second Amendment? If the answer is yes, we look at the text of the Second Amendment as informed by history and tradition to see, is this something that the government regulated at the time of the adoption of the Second Amendment in 1791? And that brings us to Oakland Tactical Supply v. Howell Township. We'll throw the case up there if you want to check it out, 23-1179. And what is going on in this case?
Well, we have a party who wants to open a gun range in this city. This would be fantastic for the people who live there because there is not, in fact, any range in the entire city, and you have to drive over an hour to get to a gun range. They try to do it. The city says, no, 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 you're not zoned for that. And specifically, they want a range in which you can have 1,000-yard rifle range, which that is something we have in our area, like
Multiple.
everywhere.
Yeah. Multiple.
Everywhere. I don't
Yeah.
have to drive more than 20 minutes to get to a 1,000-yard rifle range right now.
Yeah, and the kind of history of this case is a little bit bizarre. It started back in 2017, and this is prior to New York State Rifle and Pistol Association. Oakland Tactical, they leased a gigantic piece of property, over 350 acres. Wasn't zoned for outdoor shooting ranges. They tried to get some variances. They're working with the city. All those claims kind of get exhausted. They don't get any relief, and so they sue ultimately. But in the meantime, while this is going, we get New York State Rifle and Pistol Association, and the district court denied relief for them, went up to the circuit court. Bruen happened. They sent it back down to the district court saying, hey, district court, evaluate this under New York State Rifle and Pistol Association. Again, the district court denied it, lands back up in the Sixth Circuit, and we do not get any relief here.
We don't. We played Second Amendment ping pong for years, and here we have it. We have the Sixth Circuit saying, okay, we actually agree with the district court's denial again, and why? And this is where the reasoning starts to get enraging, because I guess it would be one thing if they were like, Second Amendment doesn't cover training, and that's enraging enough, but they know they can't do that.
No, they get really close, though.
They get really sneaky about it because, yeah, they're like, of course the Second Amendment covers training.
We got that out of Heller.
Yeah, you have to be able to use it. It's in everyone's best interest. So, don't worry. The Second Amendment definitely covers your ability to train. However, with two caveats. Caveat 2 being more enraging, but we'll talk about that in a second. Caveat 1 being, but Bruen doesn't implicate zoning laws.
Yeah.
Bruen doesn't implicate zoning. Well, then how do you train?
Exactly right. And so we see this trend of, local governments trying to chip away at a fantastic opinion that we have in New York State Rifle and Pistol Association, figure out there are ways around the Second Amendment. And I think all of these courts have these things turned on their heads because we say, is Second Amendment implicated? Answer, yes. Step 2, government demonstrate why this is something that you're allowed to regulate. The presumption is you can't regulate it. And so the courts don't seem to be following those instructions.
No, they're saying, "Oh yeah, you have the right to train, sure, but zoning doesn't directly implicate that. And this zoning law doesn't say you can't have a gun range. It doesn't effectively ban all gun ranges. It's just not exactly the kind that you want, and maybe someone just hasn't tried to open one in the right area. And so there's just a million caveats by the court to say, "No, this isn't. I mean, we get it, guys. You're allowed to train, but this just, you're being hysterical."
Yeah. And so, I mean, that's the trend we see with local governments not faithfully applying New York State Rifle and Pistol Association, and courts kind of giving them cover for it. And again, I mean, this is a panel decision, so we have 3 justices on the Sixth Circuit. I imagine they're going to ask for a full panel review, and I imagine this thing goes up to the Supreme Court, but there's some disturbing kind of fact finding and analysis in this.
There is. And what's really enraging, although it's not the most enraging part, and I think we'll talk about that a little bit later, but what's really enraging to me here is that they in trying to sneak their way out of Bruen analysis, they still acknowledge that we have a right to train.
Yep.
That the Second Amendment says you can train with your firearm. You have to be able to have that right. However, once you say that to me, it's really hard to get yourself out of saying this doesn't implicate Bruen. And that's the part that's really intellectually dishonest here, is that they say you have the right to train, but this isn't a law that says you're not allowed to train. It's just a zoning ordinance, guys. Calm down.
Right. And in the meantime, and what added some confusion to this is the particular parcel of land was zoned for agriculture purposes. And the city, even though they wouldn't grant them a variance to allow them or amend the ordinance so that they could, kind of use it for their intended purpose, they went around and started passing these other ordinances defining what sports shooting ranges are, what indoor ranges are, what outdoor ranges are, say where they apply, but at the same time will not let anybody build the facilities that they want, because ultimately this comes down to long range shooting.
Right. And so there are, although no ranges in the city right now, which is unfortunate because I don't think it's fair to ask someone to drive an hour and a half to get to a range where they can practice. Essentially the court says, but look, there can be indoor ranges wherever. People just haven't really done it yet. And so this isn't a, unlawful restriction on the Second Amendment. This is just, I guess, an unfortunate set of circumstances for anyone who wants to train, except for when it comes to long-range rifle shooting. And this is what could actually, under the zoning ordinances, I think even the court agrees that basically you're not going to get 1,000-yard range in the city.
Yeah,
it's not going to happen.
I think
They've zoned it out of existence.
I think they acknowledge it.
Yes. So, but the court says you don't have a right to that. You don't have a right to a rifle range.
Right. During the Revolutionary War, when revolutionary soldiers are shooting, the most they ever shot was 900 yards. So why would anybody need to train for 1,000?
Well, and they use, that's an argument by the plaintiffs, which is, look, in 1776, riflemen were shooting 600 to 900 yards, and they had to do so effectively, which is why this government exists. And they really kind of laugh about that argument. I'm reading into the opinion, obviously, because it's on paper, but they're like, we don't find that persuasive. There's no reason anyone needs to be able to shoot at 1,000 yards. That is wild.
Yeah.
Wild.
Don't need to be able to operate it at 1,000. Slippery slope. Who needs to defend themselves inside of 35 yards? Who needs to defend themselves at less than 10 yards?
Right. Also, if I'm the government and I'm starting to say, you don't really need to be that good of a shot, citizen.
Yeah.
That scares me.
It's kind of the same arguments we saw with function enhancing modifications to what gun grabbers call assault weapons. If you're listening, I'm making air quotes. But it's like, the government doesn't want you to shoot good.
I know. Do I need to start saying every time I roll my eyes for people who just listen?
I don't know. Let us know. I don't know. Let us know in the comments.
That's going to be we're going to make real long videos if I have to say that every time.
Emily's eyes are in the back of her head.
But no, it is, It is a disturbing carve out from Bruen, which we are seeing more and more of. Oh, well, this doesn't implicate Bruen. This doesn't implicate Bruen. If you have even a small avenue to exercise this part of your right, this doesn't implicate Bruen. So we're seeing how the lower courts are, in fact, chipping away. And then, I hate to think that the government truly does not want us to be trained in the use of our firearms, but I think that it is as clear now as ever that it is not a priority
But I think the
in the
tactic,
least.
yeah, but I think the tactic is just so that everybody kind of puts their spidey senses on high alert. What the government is doing is taking some other area where they're allowed to regulate, think taxes, think zoning, think these things that aren't traditionally connected to the Second Amendment, and then they're commingling them and watering down. And so, I mean, that's kind of the strategy.
Yes, and um, what does the Supreme Court do? I mean, what does the Supreme Court do? I mean, if they were to take up every single case that misapplied Bruen, it is literally all they would do, all all session long.
Yeah, I mean, I was just looking at the negative treatment. So, when we evaluate cases, we look at, hey, if this decision is reinforced, it's a cited by treatment. If they are kind of figuring out some wiggle room, we call it a negative treatment or a decline to be used treatment. There are thousands of cases where courts have declined to use New York State rifle and pistol.
Yes, and so I mean, it is like a mass revolt from the judiciary in lots of parts of the country, and I would not want to be sitting on the Supreme Court trying to figure out what we pick and choose in order to fix this, because it is a job.
Even though it's not a happy discussion, we hope you enjoyed it. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please click the link in the description, sign up for our newsletter. Until next time, we're the Armed Attorneys.